Hello friends, hope you're doing well. Chris Lee, CPA here, back with another video today. So today we're going to talk a little bit about the basics of trusts and kind of what they are for tax purposes, okay? So when it comes to your estate plan, this is how you manage your assets after you've passed away. It is common that you'd hear some sort of trust be talked about by an attorney. So when it comes to trusts, most commonly, attorneys are going to use, estate planning attorneys are going to use language that is going to refer to as a revocable trust or a revocable trust, or quote unquote irrevocable trusts or irrevocable trusts. So they're different pronunciation of the same thing. And so that we've kind of got two categories of trusts that estate planning attorneys are going to be talking about. And then from the tax side, we have to determine what happens there because there's different language that's used there. So when we're talking about estate planning, what is a trust? Trusts are fundamentally a place to title assets that can be, manage and bypass probate when you pass away. Now, when it comes to, we have kind of two categories when it comes to estate planning. So there's estate planning in, winding up your affairs and how we're going to do that. But then there is quote unquote estate tax planning. And so what that is if your assets grow large enough that upon your death, you exceed, the annual exemption as allowed by Congress and set forth, and, indexed for inflation by the IRS, that the assets, everything you own and control, basically your net worth upon your death, might be taxable. So currently in 2026, we have an estate tax exemption for assets for a net worth up to $15 million, and then for a single person, and $30 million for a married filing joint couple. And so that's fundamentally, if you die and your net worth exceeds that amount, then the estate tax will kick in at about a value at a rate of 40% on your assets. Now, the interesting thing when it comes to estate taxes is that the estate tax taxes both your liquid assets and illiquid assets. However, those illiquid assets are going to create a debt for you upon death. However, they're not a way to satisfy the debt obligation that is going to be assessed by the IRS. So we've got some issues that we need to deal with there and manage whether or not those assets are going to be taxed and how all of that works. And we use trusts to do that. Now, that's where we get into the different types of trusts and how they're going to be treated for, tax purposes. So for tax purposes, we're looking at we've got our legal definitions, which is a revocable trust and an irrevocable trust. On the tax side, we care about whether or not it is quote unquote a grantor trust or a non-grantor trust. So either one of those items there can be considered. So either a revocable trust or an irrevocable trust can fall into either bucket. Typically, most trusts are going to fall into quote unquote the grantor trust bucket. And then we can, make sure, and that in certain planning, we are wanting to have a non-grantor trust. So we're going to talk about what those terms mean and how we kind of, go about it. So when it comes to a grantor trust, which is, the tax is a tax term to describe a trust where the person, the grantor that's, contributing assets to the trust, is still treated as the owner of the property for income tax purposes. So what that means is when the grantor capitalizes or funds the trust, however you want to call it, the income generated by the trust is still going to be attributed to the grantor rather than the trust itself. So that is to say, the trust is a place to hold assets, but it doesn't really do anything else. It doesn't pay tax. It doesn't incur a tax liability. The only thing it does is a bucket to more efficiently administer your affairs, because when you pass away, the assets named to the trust are going to bypass any probate. So probate is the court sequenced process of how to distribute your assets and settle your debts upon your death, assuming in accordance with the will. Most people, when we're doing estate planning, you'll use what's called a pour over will. So your will is basically to say any assets I haven't already named, just pour over into the trust, and then the trust is going to wind up all your affairs privately, which is better, which is, typically more efficient than being in the court proceedings. And then also, it's a private affair. Anything that's related to probate is usually a public record. So if you want to keep your affairs private, you will, avoid probate at all costs. So anyway, again, the grantor trust, though, is basically invisible for tax purposes, both income tax purposes and estate tax purposes. When you put assets in there, it's still treated as you own them for both, honestly, legal purposes and for tax purposes. So the key feature of a grantor trust is that it, has certain powers and control over the trust assets that basically means you're the substantial owner for tax purposes. And so because of that, there's no income tax change from putting into the trust, and then there's also no estate tax change. Now, very few people honestly need to worry about estate taxes because their net worth is not, greater than 15 million or 30 million for a couple. But if we were going to be, trying to achieve certain estate tax consequences, usually a grantor trust is not the right avenue to go. There can be reasons to use it and specific language that we can, use to create trusts that are grantor for during your life. However, they still get excluded from your estate, but those are some special trust arrangements. An individual who creates a trust that is taxed as a grantor trust typically has, certain powers over the trust that make it kind of invisible for both income tax and estate tax purposes. And that is, you retain some amount of power to revoke or terminate the trust. You can make changes or amendments to the trust documents. You have some ability to manage or control the investments within the trusts. You can direct how and when the trust distributions are made, the power to change the trust, the power to substitute the assets, the power to borrow from the trust, all those sorts of things. All those powers that, basically mean your economics haven't changed related to those assets are also the reason that there are no changes for income tax purposes or estate tax purposes. The most important thing to understand when it comes to taxes is the taxes are going to follow the economics. So if your economics don't change, the taxes don't change. And so that's the most important thing to understand. And because of those powers just mentioned a moment ago, you basically end up with, because you have so much control over the assets, nothing has changed. So from a tax perspective, again, this is to say it's basically treated as a disregarded entity. Sometimes it may or may not have its own, tax identification number. But even so, even if it did have its own tax ID number, for income, the income earnings on the trust assets are all going to pass through and go to the grantor. So say I form a trust, it's a grantor trust. Maybe I put, a certain amount of portfolio, assets into that trust. It generates $10,000 of capital gains for the year. It's a grantor trust. Nothing happens. It doesn't go file a tax return or anything. I just include that on my own personal tax return. For estate tax purposes, so that's to say that's how a grantor trust is going to work. For estate tax purposes, because the grantor, the person funding the trust does not relinquish control over the assets, they're still part of the estate. So when you pass away and you're doing that counting of what is your net worth, to determine if you have a taxable estate, you're trying to determine what assets are quote unquote in your estate versus out of your estate. Basically anything, most of the time, anything that's in a grantor trust is going to be included in your estate counting. So the accounting of your net worth upon your death is anything that's in a grantor trust gets included in the estate. Since the trust assets were never removed, are never outside of your control, they're still attributed to you upon death. So since the trust assets aren't removed from the estate, placing them into a grantor trust does not trigger estate tax benefits, but that also has to mean it doesn't trigger gift tax consequences. So gift tax and estate tax are kind of like, two separate pieces. As noted on the top, the 15 million exemption, right? Like if your net worth is below 15 million, it doesn't matter. When we start trying to do that math, we have to consider what assets did you give away during life, and those assets that you gift away reduce your, 15 million threshold that you may have, or your 30 million threshold upon your death. So one strategy that does allow individuals to reduce estate taxes while still retaining the grantor powers is a trust arrangement called an intentionally defective grantor trust. It's an irrevocable trust created during the grantor's lifetime that is defective for income tax purposes only. There's enough in there. It's the terms of the trust are written in such a way, very particular way, to say that the trust assets, the income is going to be attributed to the grantor. However, it is still going to be excluded from their estate. So the powers, that big long list of powers that basically said, because you have these powers, you don't have there's no income tax change, there's no estate tax change. When you take those powers and you restrict them down to only such a small amount, you can get the benefit of removing it from your estate. However, it's going to remain, invisible. The trust is invisible for income tax purposes. The fun thing about that is that when you do that, and you have a good reason to do it, is that when you pay the tax on those assets, right, during your lifetime, we don't incur gift tax consequences on those assets. So that is to say that we remove the tax drag on those assets that you're trying to pass to your heirs. And so that without it having any consequences on your estate. So estate or the assets that you're going to save. So basically you're keeping the bucket as high up as you possibly can for the assets that you can transfer. So if you want to, if you're forming a trust that you want to retain control of your assets while you're alive and don't mind paying the income taxes on the earnings of the trust, the grantor trust is the way to go, which is usually for when your trust documents are being written. They're going to be quote unquote revocable trusts. Since taxes don't have to be paid directly out of the trust, this might allow the trust assets to grow faster, again reducing that tax drag. You can also use, even if you've got a larger estate planning strategy because you're worried about these estate taxes, you can still use grantor trusts as part of that. Some common types of trusts that you will see that are, quote unquote grantor trusts are, a grantor retained annuity trust, spousal lifetime access trust, irrevocable life insurance trusts, and, then again, any trust that says revocable on the front of it. Sometimes attorneys will say revocable. We use the word revoke, I say, revocable. So usually you'll set these up with, an estate planning attorney, and, they'll discuss kind of all the terms that go in there. So now the opposite side of that, so that is to say the majority of trusts that are created are grantor trusts because, for income tax purposes, nothing changes. Trusts, to be totally honest, is like a trust that has income tax responsibilities is like very inefficient from an income tax perspective. We use those types of trusts to deal with estate planning concepts, and so most of the time for most clients, we're in the revocable trust planning camp. For now, if we are looking to have a trust that is not disregarded but is actually regarded and has its own consequences, you'll be looking for the tax classification is going to be a non-grantor trust. So non-grantor trusts are where you relinquish control over the assets and the property that are placed into the trust, after that trust is established. So you title the assets to it, it gets its own tax ID number, all those things. You relinquish control. then the tax consequences also go with it. So unlike, a grantor trust where it's considered the owner, the grantor is the owner of the property, the trust is the owner of the property for both, kind of basically legal purposes and for tax purposes. This is to say also kind of like a side note is that grantor trusts are not great for asset protection from creditors. The reason is because there's so much control over the assets that the creditors can get to it. So I've heard attorneys say before, if you can control it, creditors can get to it, and so that's why grantor trusts aren't great for that. So, but yeah, when it comes to a non-grantor trust, this is a separate, legal and taxable entity. A lot of times, it's going to come with that asset protection because you don't have the control over it. And so it's going to have its own tax ID number. It's going to file its own return, all those sorts of things. The grantor does not. So the thing about a non-grantor trust is that the grantor typically does not retain the power to revoke the trust or make any significant changes to its terms. The benefit of this feature is that it provides, again, the asset protection that you might be looking for, and it removes those assets from the accounting of your net worth when you die, that estate. And the reason we do this is we want assets to grow outside of our estate. So if we have high growth assets that we're worried about that if we project it out in 20 years, we're going to have more than we could ever spend. It's going to grow. The value of the asset's going to grow faster than the exemption the IRS is providing us. We don't want to get taxed potentially 40% on an illiquid asset. So we use non-grantor trusts to separate those out, get it out of our estate today at a lower value, and we give up control. When you give up control, though, you also give up a lot of the benefits of those assets. So again, non-grantor trusts, because the tax brackets for trusts are so condensed, they basically get to the highest tax rate very, very quickly. They're not efficient from an income tax perspective. However, if you said that asset's going to grow significantly and be taxed at 40%, regardless of your liquidity capacity, that is a huge problem you have to plan for, and that's why we would use a non-grantor trust. So when it comes to these non-grantor trusts, you're going to ask yourself who controls assets then, and that is the trustee, which is the person who gets the power to manage and distribute the assets in accordance with the trust terms. So the trust terms is a document that says this is how the trust is to be administered, here's all the things that are about to happen, and you go from there. So when setting up the trust, the person capitalizing the trust, the grantor, gets to specify the trustee and the successor of the trustee of the trust and all those sorts of things. So basically do all the planning of how this trust is going to continue to be administered. From a tax perspective, the income generated off of the assets within the trust are taxed at the trust level rather than being passed through to the owner. So in a grantor trust, everything just gets attributed to the owner of it. In a non-grantor trust, everything is taxed generally to the trust. so that's anything that's not distributed out gets taxed to the trust itself. So what can happen though, so like I said, if it's retained by the trust, it gets taxed to the trust. If it is distributed out to beneficiaries, that or if the trust documents require that the funds be distributed, even if not, the earnings get taxed to the beneficiaries. So the reason we do this, or the reason you might do this, part of the reason, is that beneficiaries are probably a lower tax bracket because, like I was saying, the tax brackets for trusts are very, very short. You get the highest tax rate very, very quickly. So because the assets are effectively transferred out of the state so that's all the income tax consequences. So the trust, any income, the income generated off of the assets of the trust get taxed to the trust if it's retained in the trust. If it's, if the underlying documents required to be distributed out to beneficiaries, it gets taxed to the beneficiaries. That is to say, even if there is no actual distribution, they can still be taxed to, so even if no cash left the trust to the beneficiaries, the people that receive the benefit of that trust assets, the tax consequences can still follow and should still follow according to the trust document. So if the beneficiary is having, a tax consequence that they can't burden because of the lack of liquidity provided by the trust, that's when you consult the trustee, say, hey, why aren't you making the distributions? I'm receiving these tax consequences, but no funds to pay the tax bill. What's up? That's where you can have, legal disputes of how's the trust being administered and if it's being administered properly. From an estate tax perspective, because you've given up, basically complete control of the assets, they are removed from your estate, and the process of removing items from your estate can be, subject to quote unquote gift tax responsibilities. So when you move assets out of your estate during your life, you also have to do an accounting of removing them from your lifetime exemptions, your estate exemption that is basically that's giving you that $15 million. So if you move assets out above the annual gift exemption per person, you're going to reduce your lifetime exemption and carry that forward. When it comes to estate and gift taxes, the assets transferred into a non-grantor trusts, again, they are generally front word trust name is irrevocable. There are those gift tax consequences. However, if the amount transferred into the trust is less than $19,000 for 2026, and it's a present gift, we'll say that, the present asset, present interest in it, then you can use the exclusion, the annual exclusion, and then anything above that, and that's for each beneficiary. Anything above that is going to be eating up your lifetime exemption. So when you consider a non-grantor trust is if you have concerns about asset protection or want to move, those fast-growing assets out of your estate to say, either to save on income taxes while you're alive or to manage your estate tax consequences when you're gone. So that's why you use a non-grantor trust. However, you have to keep in mind that you'll no longer have control of the assets. So if it's an asset, that's the thing with when you're doing trust planning and estate tax planning, planning for your estate taxes, is that if you're not willing to give up control, then you're going to have a tax consequence. Those taxes are, both from an income perspective and from an estate tax perspective, they're going to fall on you. So you just have to be conscientious of that. If you don't want to give up control, then everything's going to stay with you in the end. So when you're setting up, a grantor trust, you basically are going to meet with an estate attorney. Hopefully they're good enough to, give you some amount of advice of what this is going to look like, and then maybe work with your CPA and, devising the right plan for you. So once you form and fund the trust, however, you're going to no longer have the ability to make changes to the trust. So when you're doing, irrevocable and or non-grantor trust planning, you just have to understand that this is very permanent, and so you're going to have to, just be okay with those consequences. Common types of non-grantor trusts that you might see in name are, a bypass trust, various types of charitable trusts, so a charitable remainder trust, a charitable lead trust, qualified personal residence trust, qualified domestic trusts, all those sorts of things. There are so many of them, but the main difference between grantor and non-grantor trusts is the tax treatment. Grantors still have control over the assets, and so generally all the income tax is going to flow to the grantor, the person setting up the trust, and then usually for estate tax purposes, it's still going to be included in the estate. In a non-grantor trust, as the definition implies, the trust is the opposite of a grantor trust. The individual creating the trust does not retain the power over the assets, and so the income is taxed to the trust, and then also it's removed from your estate. It also has some amount of capacity for asset protection as well. So those are the key differences when you're thinking of grantor versus non-grantor. I like to think of those more as tax terms, honestly, and then when we're thinking about what type of trust we're dealing with is revocable versus non-revocable, those being more the legal terms. Estate for estate planning purposes. And then when we're talking about grantor versus non-grantor, those are terms that are more specific to tax. We're thinking of, income tax consequences related to these types of trust arrangements. So that's just a little bit of, kind of understanding some of the definitions of the words you might hear. If you're, a high earner, not rich yet, or, kind of early high net worth, these are things that you're gonna have to deal with in this near future, and all those sorts of things. So understanding the language that might be thrown at you is pretty important. And then, the more familiarity you have, the better you can make choices going forward. So with that, if you have a need for, a direct consult, feel free to click the link in the video bio, and then I'll have a new video for you soon. All right, take care. Bye.